Hi, Assalamualaikum. My name is Muhammad bin SHUHAIMI and my previous school is Sekolah Menengah Kebangsaan Agama Sikh in Kedah. I've always been fascinated by justice and how it shapes our society. Studying law will give me the tools to understand and contributed meaningfully to our legal system. My plan after finishing diploma. If fate allows me to complete my diploma, I plan to continue my education by applying degree in law program. Beyond law, I'm passionate about education. My dream is to become a teacher actually and make positive impact on students' life through mentorship and education. This semester, I've sharpened my skills in legal research, critical thinking, and effective communication, which are crucial for both my legal studies and future career in education, insyaAllah.
Assalamualaikum warahmatullahi wabarakatuh. My name is FARINI binti KHAIRUDDIN, matric number 075049. And my previous school is Sekolah Agama Menengah Jeram in Kuala Selangor. And my motivation to enter into a law school is the career opportunities. And my plan after finishing my diploma is I want to pursue into a degree. And I want to make the best preparation to go through an interview to secure my place in a law school during my degree. And for the career interest, I'm interested to be a legal officer since law is a discipline that challenge my analytical thinking. And as a legal officer, I want to give the best advice and contribute to informed decision making within organization or government agencies. The skill that I gained this semester is I finally expanding my social life and meet a lot of new people, and it helps me to improve my networking skills.
Hi, Assalamualaikum. My full name is AJMILA ZARIF binti RUSLI, and my friend call me with the name Mila. My family members call me Kakak, and I am the second daughter out of 4 siblings. My educational background is I studied in primary school in Sekolah Kebangsaan Kota Klang 1 in Jeran, Pahang, and I continue my high school in Sekolah Berasrama Penuh Integrasi Temerloh. I studied in SBPI Temerloh since I was in Form 1 till I was in Form 5. One of my primary motivation started when I was 12. I was watching a K-drama about a prosecutor, and since that I have this desire to become a prosecutor or a lawyer one day. Another primary reason is because I really fond in reading and memorizing. I can memorize things really easily rather than using numbers, calculate, and I am not really good in math. And since that I started to think that why don't I pursue something that I am special in. So my plans after diploma is I want to apply for overseas university for law degree, especially the University of Edinburgh. Why the University of Edinburgh? Because it is a really pretty university. And the next one is I want to apply for scholarships once I got the invitation to pursue my study in overseas, inshallah. And I also want to work as a librarian while waiting for the result, because librarian is also one of my dream ambition if money doesn't matter. My career interest is I want to specialize in criminal law, even though I haven't learned this subject yet. But I think I would like this subject once I have learned it. And I aim to work in a legal capacity, focus in criminal defense and prosecution. And I also wanted to become a respected criminal lawyer, known for in-depth knowledge and also ethical practice. Inshallah. The skills I gained this semester is my presentation skill. Before this, I feel a little bit shy to present in front of my friends. But since this semester provided us with too many presentations, I think I have built up the confidence to present in front of many people.
Assalamualaikum. My name is MIFTHAUL IBTISAM binti RIDZWAN. My previous school was Sekolah Berasrama Penuh Integrasi Tun Abdul Razak. Honestly, I decided to join this law school because of the subject I studied before called Pendidikan Syariah Islamiyah. In that class, we learned a lot about law, especially Islamic law. There was even a section specifically about the Sharia court in Malaysia. For now, I think after I finish my diploma, I plan to continue my studies and go for a degree. I'm really interested in becoming a lawyer because it's a job where you defend the people and you know and understand what is right and what is wrong. Plus, being a lawyer is all about fairness, and they always look so charismatic. The skill I gained this semester is, I think, communication skill, because this semester has a lot of presentation in various subjects. And also, I can improve my video making skill since there are many assignments that need to be done through the video this semester.
My name is TENGKU SYAFINAZ binti TENGKU MOHAMED KAMALLUDIN. My previous school is Sekolah Menengah Agama Kampung Laut. My motivation to enter law school is having a curiosity to discover about law and wanting to learn about the English of law. My plan after finish diploma, if I got a good result, I maybe continue to degree which is criminal law. And then my career interest is also criminal law type of job. I also want to avoid Sharia no matter what, even though my mom really wants me to choose Sharia career, but I don't want it. Skills that I gained this semester in my essay writing has improved than before, and I also got better at searching cases online, also an article, but I'm still lacking to answer a solving question without internet. So yes, that is all.
Hello everyone. Today our objective is to analyze an important question in the world of online shopping, which is whether adding an item to an online shopping cart constitutes a binding contract under Malaysian and Islamic law. This topic is crucial for both e-commerce businesses and consumers to understand their legal obligations and protection. We will cover relevant legal provisions, examine case studies, look at how this action impacts contract formations, and discuss possible remedies and solutions. Understanding this legal interpretation is essential for ensuring compliance and protecting the interests of all parties involved in online shopping. Now, the issue is, does the act of adding an item to the basket on a commerce platform amount to a binding contract under Malaysian law and Islamic law?
So I'm going to explain what is offer under Malaysian law first. So according to Section 2 Subsection A in Contracts Act 1950, offer is an expression of willingness to enter into a contract on certain terms, made with the intention that it shall become binding as soon as it is accepted by the person to whom it is addressed. Under offer, we have invitations to treat. So what is invitation to trade? Invitation to trade is an invitation to enter into a contract, negotiate or deal, hence make no legal consequence and cannot be accepted to bring about a valid contract. So one of invitation to trade is a display of goods. So basically, display of goods generally does not constitute an offer, but merely an invitation to trade. So in this situation, the customer will become the offerer. So the display of goods with or without prices marked on shelf are not an offer, but merely an invitation to trade. When does the offer is constitute? So the offer is constituted when the customer took the goods from the shelf and put them in their basket with the desire to buy them, normally by taking the goods to the cashier. So the binding contract is formed once the goods is paid to the cashier, and the cashier has the option whether they want to accept or reject the offer by the customer. So one of notable cases is the case of Pharmaceutical Society of Great Britain and Boots Cash Chemist. So in this case, the defendant runs a self-service drug shop. The defendant was then prosecuted under Pharmacy Poisons Act 1933, which prohibited the sales of drugs without the supervision of a registered chemist. So the prosecution alleged that the display of the drugs with prices marked constitute an offer. Hence, making a sale of goods is constituted or formed at this point, making the sale was carried out without the supervision of registered chemists. However, the court held that the display of goods was not an offer but merely an invitation to trade, and the defendant escaped liabilities. In online shopping platform situation, once we search for something that we want on the search bar and the display of the goods was not an offer but merely an invitation to trade, it is the same of display of goods in shelf in a supermarket. What happened once we added the item into the cart? Once we added the item into the cart, it does not constitute an offer, but we merely showing our interest in purchasing the items. So, when does the offer constitute? The offer constitute once the customer proceeds to check out the offer and provides payment confirmation. So, once the payment was made, there's a binding contract between the seller and the purchaser. So the seller will confirm the order and process the shipping, which means that when the seller processes the shipping, this means that the communication of acceptance already completed between the as against the offerer. So in this situation, the seller can accept or reject the offer made by the customer. How? For example, by stating that the goods is out of stock temporarily, or by stating that there is a pricing error, or the seller does not receive any payment as an acceptance from the buyer. So generally, adding items into online shopping cart does not constitute an offer, but merely showing our interest in purchasing the items.
In Surah Al-Ma'idah, Ya ayyuhallazina amanu awfu bil uqud explain about the freedom of contract, and in Surah Al-Baqarah, wa ahallallahu al-bai'a wa harrama riba explain about the necessity for Muslim to engage in buying and selling according to Sharia guidance. In hadith, an Rafa'ah bin Rafi' radiyallahu anhu anna Nabi sallallahu alaihi wasallam su'ila ayyul kasbi atyabu qala amala rajulu biyadihi Kullu bay'in mabrur. The Prophet ﷺ was asked, what type of earning is best? He replied, a man's work with his hand and every transaction which is free from cheating or deception. This verse encouraged Muslims to engage in honest work, whether through manual labor or business transaction, while avoiding any cheating or deception. Based on scholars of ijma, buying and selling is permissible and has been practiced since the time of Rasulullah SAW is up to the present. And ulama have agreed that buying and selling is allowed on the grounds that humans will not be able to meet their needs without the help of the others. Buying and selling online, on the other hand, is allowed as long as the goods or products being traded follow the specification or characteristic provided in Islamic law. In Qiyas matter, I will explain about the pillars, which is the first one is the original case. The original case in this matter is in Surah Al-Baqarah, verse 275, وَأَحَلَّ اللَّهُ الْبَيْعَ وَحَرَّمَ الرِّبَا. And the new case is about the online shopping. And the illah is the concept of online shopping still use the same principle and rules as the transaction of Islamic law. And as a result of that, the permissibility of such transaction should be the same as what has been permitted in Islam itself. And the rule is mubah. Next, I will explain about the principle of contract in Islam. First, we have the ijab and kabul. The ijab is the declaration which is made first to create an obligation, and the subsequent declaration to accept the offer we call as kabul, which is acceptance. And generally, offer and acceptance conduct in the words, but they can be done by the other methods, such as writing or the conduct. Niyah and rida. Niyah is the form of intention. And Prophet ﷺ said there is no action without intention, so you need to perform some obligation or requirements to show that you have the intention for the contract. And the next is rida. Rida is to ensure that when you enter into a contract, you enter with the full acceptance and full knowledge about the contract, and you know about the consequences of the contract.
Okay, now I will discuss the relevant case studies and examples on the formation of online contracts under Islamic law. I will highlight the key principles of offer and acceptance and draw analogies from traditional Islamic contracts to modern e-commerce scenarios. Let's begin with an important case, Feldman and Google. In this case, Lauren Feldman sued Google, alleging he was a victim of click fraud through the Google AdWords program. The central issue was the enforceability of a forum selection clause within the AdWords agreement, which required legal dispute to be resolved in Santa Clara County, California. The court ruled in favor of Google, emphasizing the enforceability of online click-wrap agreement where user indicate consent by clicking yes to agree to terms. The case underscores the importance of clear notice and mutual assent in online contract. Moving on to Islamic principle. The formation of a valid contract or akad requires a clear offer and acceptance, which are ijab and qabul. Here are some relevant examples. First, hadith from Sahih al-Bukhari. Muslims are bound by their obligation, emphasizing the importance of fulfilling contractual agreement. This hadith implies that once an offer and acceptance are made, both parties must take note to the agreed terms. Second, hadith narrated by Ibn Hajar. Both parties in a contract of sale have the right of option as long as they have not separated. This introduces the concept of khiyar al-majlis, allowing either party to withdraw from the contract as long as they are still in the meeting place.
Binding contract in contract law is formed when the parties involved fulfill all necessary elements: offer, acceptance, consideration, and intention to create legal relations. This process involves one party making a clear offer, which other party accepts, thereby creating mutual agreement. Consideration must be exchanged between the parties, and there must be a clear intention to enter into a legally binding agreement. Under Islamic law of contract, a binding contract is formed when all essential elements are fulfilled. There must be a clear offer from one party and acceptance from the other. Both parties must agree on the consideration or price of the contract. They must have the legal capacity to enter into the contract, and there must be a genuine intention to create legal relations. Once these elements are fulfilled, the contract is considered valid and enforceable. In a binding performance is a legal remedy where a court compels a party to fulfill their contractual obligations. It is granted when damages wouldn't be adequate. Generally, it's not ordered if the contract requires constant watching and lacks clear terms. However, it is common in building contracts which focus on specific results and defined tasks. This remedy ensures contracts are complete. This remedy ensures contracts are completed as agreed upon. Under Section 74(1) of the Contract Act, An innocent party can claim damages for any breach of contract. Nominal damages apply when no real loss is suffered, while substantial damages compensate for actual losses. To get substantial damages, the innocent party must prove the loss and its amount. The breaching party can argue that the loss wasn't minimized. The court has the discretion to award these damages as an equitable remedy. Under Section 40, if one party refuses or is unable to fulfill the promise, the other party can end the contract unless they have clearly agreed to continue despite the breach. Any failure to perform allows the other party to resign the contract. In Islamic law, restitution for unjust enrichment due to undue influence isn't disputed. The concept is indirectly mentioned in the Quran, which is in Surah An-Nisa, Ayah 29. It's stated that, "Eat not up your property among yourselves unjustly, except it is a trade amongst you by mutual consent." Meaning, one can only hold property obtained through mutual agreement, not through undue influence, fraud, or other illegal means. In Islamic law, contractual liability for compensation is known as saman al-qud. If the contract's subject matter, like sold property, is destroyed before delivery or while hired, according to an article, any defect present while the vendor held the item justifies rejection, liability can lead to various damages for the affected party, including compensatory, sequential, punitive, and nominal damages. Rescission is an equitable right to end a contract. In Islamic law, this right allows one party to cancel or confirm a contract, especially in sales. Tawah Zuhaili notes that rescission applies to all binding contracts except marriage if the parties agree to cancel a valid. And so for the solutions, in e-commerce, terms and conditions are essential for establishing trust and clarity in transactions. They include terms of service and privacy policies, which outline user rights, refund policies, and data privacy obligations under global regulations like GDPR and PDPA. Clear agreements with vendors and suppliers that defines roles and payment terms and intellectual property rights to prevent disputes. Licensing agreements for content and software specify ownership, usage rights, and support terms, crucial for avoiding future conflicts. Contract formation is a structured process ensuring a legally binding agreement. It begins with negotiation to clarify terms and build trust. An offer is made, specifying terms followed by acceptance without modifications. Consideration, where each party exchanges something of value, makes the contract enforceable. Incorporating clear clauses about choice of law and jurisdiction in contract is crucial for clarity and preventing confusions. These clauses explicitly state which laws apply and specify the jurisdiction where disputes will be resolved, ensuring both parties understand the legal framework upfront.
Next, we will discuss how action in online shopping carts are perceived by both the public and merchants and what this means from a legal standpoint. Let's get started by examining some survey results. Firstly, let's look at the public opinion on whether adding an item to an online shopping cart constitutes an offer. We conducted a survey with the following question: do you think adding an item to an online shopping cart constitutes an offer? Here's the results. As you can see from the pie chart, 66.7% of respondents believe that adding an item does constitute an offer. Meanwhile, 25% think it does not, and 8.3% are unsure. Next, we asked respondents what they usually do after adding item to their online shopping cart. This question helps us understand consumer behavior, which is crucial for interpreting the legal implications of online shopping actions. The results shows that 25% of respondents proceed to check out and complete the purchase. Another 25% abandon the cart without purchasing, while 50% save the items for later. Let's look at merchant policies regarding actions in online shopping carts. We have gathered data from various e-commerce platforms to understand how they treat items adding to the cart. As you can see from the pie chart, the majority of merchants, about 17%, treat adding items to the cart as an intent to purchase only. Meanwhile, 30% of merchants treat it as an offer. Finally, we will examine the legal perspective on whether adding item to a shopping cart constitutes an offer. This aspect is crucial for understanding the potential legal implication for both consumers and merchants. According to our research, the legal community is divided. About 50% of legal experts believe that adding item into a shopping cart constitutes an offer, while 60% argue that it does not an offer. Therefore, we have highlighted the main points where there's the legal system coverage and leverage. First, for the divergence, Malaysian law focuses on offer and acceptance, while Islamic law emphasizes mutual consent, which is ijab and qabul, and ethical consideration. Next, for the convergence, the both law state that they have an intention to trade, which is both laws agree that adding items to the cart is not a contract. Also, secondly, binding contract formation. Both law require a clear offer and acceptance of mutual consent for a contract to be binding.
In conclusion, adding an item to an online shopping cart does not create a binding contract under Malaysian or Islamic law. It is considered an invitation to negotiate, not a final offer, and lacks the required elements for a binding agreement.